Could Corey Richins be set free both now and for good? We've got to talk about the defense's new bombshell allegation claiming that prosecutors failed not only to turn over evidence, but evidence that allegedly clears her of the murder of her husband, Eric. Welcome to Sidebar. I'm Wayback. Is Corey Richins about to get a major win? That's quite a statement, especially since we always talk about the mounting evidence against her, against this wife accused of poisoning her husband. Well, it may all center around a key witness. Let me explain. Richins is accused of murdering her husband, Eric Richins, back in March of 2022. Prosecutors say she spiked his drink, a Moscow Mule, with fentanyl the night of his death. And when I say there's mounting evidence, what do I mean? She allegedly told authorities she found her husband unresponsive at the foot of the bed when she woke up at 3 a.m. But Eric apparently had 5 times the lethal dose of fentanyl in his system. According to authorities, when they looked at her phone, they found suspicious searches. Women, Utah prison. Can cops uncover deleted messages iPhone? If someone is poisoned, what does it go down as on the death certificate? How long do life insurance companies take to pay? And what is a lethal dose of fentanyl? She allegedly tried to poison Eric's sandwich the month before on Valentine's Day. He apparently got so sick that he broke out in hives. Eric allegedly told a friend, "I think my wife tried to poison me." Behind Eric's back, she's accused of taking out a $250,000 home equity line of credit, possibly forging his signature. She was in debt while Eric was worth millions. And talking about money, she's accused of opening life insurance policies on her husband without his knowledge, totaling $2 million. And of course, if you're familiar with this case, you know she's the woman who published a book called Are You With Me after Eric's death. A book she said was meant to help kids cope with loss. She even went on local media to talk about it. And now she's accused of murdering Eric. So yeah, all of that is not great. That's a sampling of the evidence prosecutors say they have against her. She's facing multiple counts, including murder and financial crimes. But there's one other key piece of evidence, one that may tie it all together. And the update I want to talk about right now is whether it jeopardizes the entire case. Because here's the question. Where would Corey Richins have gotten the drugs from? Where did she get the fentanyl? Prosecutors say she got those pills from her housekeeper, Carmen Labor, who allegedly spoke with investigators about it. According to a search warrant affidavit, quote, Labor admitted to supplying Corey Richins with 15 to 30 fentanyl pills on 2 separate occasions, approximately 1 month before Eric's death. She stated Corey paid her approximately $900 each time she supplied the pills. She provided details of the solicitation of the drugs, the pickup and drop-off locations, and other pertinent details that have been corroborated with digital forensic evidence. So slam dunk, right? All well and good for the prosecution. Not quite. Here's the problem. Richins' defense team is now arguing, wait a second. Lauber allegedly says she got the pills from a guy named Robert Crozier. But Crozier denies this. He says he sold Lauber OxyContin, not fentanyl. The only reason Lauber thinks she gave fentanyl to Richins, according to the defense, is because that's what she thinks he was given by Crozier. This is a big development. Crozier allegedly recanted his previous statement. According to NBC, he had said back in 2023 that he sold Lauber fentanyl. But when asked now why he changed his story, Crozier allegedly said he doesn't remember what he said back then, that he was in the middle of detoxing and was out of it. He now claims he's sober. According to his affidavit, Crozier stated, "On May 4th, 2023, I had been in jail for a short time and was detoxing from drug use. I do not have any personal recollection of the details of that interview, although I have since been told that I agreed that I had sold fentanyl to Carmen Lauber in 2022 on 2 occasions. Crozier further stated that during a meeting in April 2025 with people he believed were prosecutors, he told them that wasn't true. Quote, Mr. Brentworth and the other individual asked me if I had sold fentanyl to Carmen Lauber. I told them no. I sold OxyContin to Carmen Lauber on 2 occasions in early 2022. I told them that I met her at the Maverick and Draper both times to sell her the pills. I told them that I was certain I had sold Carmen Lauber OxyContin 30 milligram pills, otherwise known as Roxy's or Roxy 30s. They asked me several times if I was sure, and I told them yes, I was sure I sold her OxyContin. So in other words, Defense attorneys are arguing that not only did prosecutors interview him in April and learn all of this, but maybe most importantly, they didn't tell the defense. That's the allegation. The defense filing states, the prosecution has been aware of this exculpatory evidence since April of this year, meaning evidence that shows the defendant is not guilty. The prosecution did not inform the defense of this information. No press release was issued, no reports, nothing. The prosecution just kept quiet. Let me say this real quick.
Even if you're not a journalist, staying on top of what's going on in the world is so important. But I'll tell you, these days, with all the media bias and mistrust, it can feel nearly impossible to know what to actually believe, right? That's why I want to introduce you to our sponsor, Straight Arrow News. It's a personalized news platform that empowers readers with unbiased, fact-based journalism, reporting that informs, educates, and actually builds trust from across the political spectrum. So how does it work? Their media mist tool opens readers' eyes to reporting that's often not seen in biased mainstream outlets. It provides useful commentary, analysis, and source transparency so readers can see what's really happening versus what's just sensational spin. And here's the difference. Straight Arrow News clearly declares the biases of their sources. Their media landscape tool groups and displays outlets according to their leanings, providing maximum transparency. So if you're ready for a better way to get the news, skip the drama, get the facts. Welcome back to Trustworthy Journalism. Now, the defense claims that the only reason they found out about all of this is because they themselves interviewed Crozier last month. Here's the big idea, as laid out by the defense in court documents. The prosecution failed to disclose evidence that not only negates Ms. Richins' guilt, but completely eviscerates the prosecution's own theory that Ms. Richins procured the fentanyl that ultimately killed her husband. The prosecution's failure to disclose and continued concealment of exculpatory evidence that Ms. Richins did not procure fentanyl has inflicted ongoing harm on Ms. Richins, the public, and the integrity of our legal system. This is precisely the type of misconduct Rule 3.8 was designed to prevent. By withholding this evidence, the prosecution abandons its duty to seek justice and undermines the assurance of a fair trial. The defense continues, if the state cannot place fentanyl in the hands of the defendant, the state has no case. Mr. Crozier's statement doesn't just poke holes in your case, it throws a grenade into the middle of it, leaving them nothing but speculation and conjecture, nowhere near the realm of beyond a reasonable doubt. In one filing, the defense is asking the court to order the prosecution to hand over all evidence, texts, emails, recordings, and correspondence between prosecutors, police, and Crozier, as well as any notes or documents that could negate Richins' guilt. But here's the question. If this is such an alleged egregious violation of the rules, could the judge actually throw out the case? We'll talk about that. By the way, the defense is also moving for the judge to reconsider bail, which has been denied multiple times in this case. We'll discuss that too. So, what exactly is going on here? Let's bring in an expert. Criminal defense attorney and former Salt Lake County Assistant District Attorney, Jeremy, thank you so much for coming on. It's really good to see you. Let's start right here. What do you make of the fact that Crozier apparently has this change in his position, this complete change in his account? Sure, I mean, it's not entirely common for stories to change this substantially, and for this case, it's a pretty big deal, I think. Such a big deal that, let me start here. Even before the allegation that the prosecution hid exculpatory evidence, is if this is true, and he supplied only oxy and not fentanyl, is that the end of the case? I mean, can they prove that Corey Richins killed her husband? I don't know if it's necessarily the end of the case because there are different things within the rules of evidence, that allow the prosecutor to bring in prior inconsistent statements. But at the same time, it doesn't help. And I think as a prosecutor, I would view it as a serious blow to the case as a whole, because if Carmen Laber says, I don't really know what I was given, I assumed it was fentanyl, he's saying, no, I gave oxy. The toxicology reports indicates that Eric had 5 times the lethal dose of fentanyl in his system. And they can't directly tie where Corey Richins got it from. I mean, I wonder, first of all, how do prosecutors change their case? Do they still call him to the stand? Do they still call Carmen Laber to the stand? Do they forget about where she got the fentanyl pills from, allegedly? I mean, how does this change the whole prosecution's case? But remember, you still have the fact that, according to Carmen Laber, Corey asked for fentanyl, right? So as a defense, you still have that to deal with. And as a prosecutor, you still have that kind of in your pocket. Why is Corey asking for fentanyl in general? So, I mean, even though this delivery system that they've alleged, this Carmen Laber to revert back to Carmen Laber and then back to Corey, that whole thing, that may have fallen apart. What the state certainly doesn't have is any sort of new, I guess, bridge to the fentanyl, but there's still the fact that, according to Carmen, Corey was asking for fentanyl.
So you still have that to deal with, and it's depending on what side you're on, you have arguments to make. But by the way, we're also making this argument assuming he's telling the truth now, right? Is he the most credible witness? He may have actually given fentanyl, we don't know. So there are a lot of things that you look at when you're weighing credibility, right? And really one of the things you look at is, what is the motive here? What's the motive to lie? What's the motive to change the story? And that's going to be something that's hard to kind of argue against as a prosecutor here. Certainly, like I said, another feather in the cap for the defense team. Did the prosecution violate the rules regarding turning over material to the defense? Turning over material that is potentially exculpatory, material that negates a defendant's guilt. What is the standard? And did they violate it? Man, that's hard because it's a bit of a gray area. I think that it's certainly poor form. When I was a prosecutor, as you mentioned, I was a prior prosecutor, the hope is that as a prosecutor, you were trying to go above and beyond and kind of be above reproach. So the hope would have been that when they had the conversation with Robert Crozier, that they would have disclosed that conversation with the defense. The fact that the defense is just hearing about that, according to the defense team, in September, from April to September, by my math, that's 5 months. And they haven't disclosed such a big thing. Again, I want to be clear, this is a big deal. The fact that he's saying he was not the person who gave fentanyl, him changing his story, is a big deal. And that's something that I think should have been disclosed back as soon as possible in April. I mean, you would certainly think and hope that a prosecutor on the drive back to the office after meeting in the Starbucks coffee shop would have said, hey, we've got a problem. This is what the witness is telling us now.
You may want to have somebody go out and reach out to him and kind of interview him. And one of the things that kind of surprises me here is that the prosecution team didn't themselves send out an investigator to kind of get this new information and somehow get it to the defense team. So I think it is a concern. There is an element of timeliness as far as disclosure. They don't necessarily have to disclose it immediately, but they do have to disclose it timely. So whether or not they're kind of in this little bit of a gray area. I mean, it's September. They still haven't disclosed it to the defense team. They're set for trial in February. I'm surprised that it hadn't been disclosed.
Well, that's the point. When the defense comes out and says, the only reason we found out about this is because we interviewed him ourselves and found out what would be the defense for the prosecution. I think this is something that the defense mentioned in their filing, that what's the prosecution going to argue? That it was an oversight? Is that the argument from the prosecutors? Hey, we didn't deliberately withhold evidence. This was an oversight of some way. We were trying to corroborate it. But is it even their responsibility to corroborate it, or is it just to turn it over to the defense immediately? I mean, what seems like this was a mistake. This was an oversight. It wasn't intentional. That would be the prosecution's defense here, right? Well, I mean, it would have to be, look, it was just an oversight. But at the same time, that is a big oversight, right? I mean, that's some pretty critical evidence when it relates to this case. I would think that they would have to say it was an oversight.
I think it's going to be something along the lines of, we were busy, we weren't sure how reliable it was. But I mean, even at that, when it comes down to reliability, that shouldn't necessarily be the prosecutor's decision to make. That's something that should be made after having disclosed it to defense counsel. This is such a big issue that I am curious, different scenario, But if you remember what happened in the Alec Baldwin case, there was a serious issue about evidence being turned over to the defense where his case was dismissed.
I mean, if I'm remembering correctly, I believe that's what happened. Is that something that could happen here? The judge could look at this and say, this is a total travesty, this is an injustice, Corey Richins' rights were violated, I am dismissing this case. Is that an actual consequence if the prosecution really violated their duty? I think it's possible. I think it probably has to be more egregious, at least the violation, in order to get to that point, but I mean, it's on the table. I just don't think it's likely. What could be a punishment for the prosecution? That's a good question. It's going to be interesting to see. I don't know exactly how the judge would rule or really what's on the table for that. What about agreeing with the defense? Prosecutors, you got to turn over all this evidence. So not only evidence that would negate Corey Richins' guilt, which obviously they should be turning over anyway, but every correspondence regarding Crozier, everything regarding him. Do you think the judge will grant that request? I think he will. It's not a guarantee that he will, but given the circumstances, given the whole high-profile nature of the case, I think he will order that that be turned over. Will that delay this case? I mean, her trial is scheduled for February. Does this now put a wrench in all of this? It's possible. It depends on, number one, how quickly it takes the prosecutor's office to get the defense team the discovery, and what the defense team's able to do with it once they get it. How long does it take them to fully review and fully vet any new information that they get from that disclosure? By the way, I'll talk about bail in a second. As we're going through this, I'm thinking, if now the prosecution is struggling to prove that she got those pills from Carmen LeBurn and Robert Crozier, if they can't establish that, how do they prove the pills were in her possession? I mean, does that show a weakness in the investigation? Can they not pinpoint another alternative by which she would have gotten those pills? Because they have to establish, I think in some way, where did she get them from? Otherwise, that's something the defense is going to jump on in an opening statement, a closing argument during the course of the trial. And if they can't establish that, does that show a weakness, a gap in the investigation? So I don't know if it's enough to necessarily get the case thrown out. Remember, this case has always been circumstantial.
The question when it comes to circumstantial cases is how strong is that circumstantial case? It's absolutely weaker with Robert Crozier's disclosures that he never gave fentanyl. But the prosecutor still has the fact, according to Carmen Lure, that Corey was asking for fentanyl. So you have Eric overdosing on fentanyl, you have Corey asking for fentanyl, you still have that to use as evidence. And is your case weaker without that bridge that shows this is where she got the fentanyl from? Yeah, it's weaker, but at the same time, it's still something that the prosecutor's office could potentially go forward on. But yes, you're right, it is a weaker case because they can't point to the distribution route that Corey allegedly took to get the fentanyl. I want to talk bail here, okay? And I want to talk the defense's motion for the court to reconsider it and for Richins to be released in light of this development. Because again, she has been denied bail twice so far. So they cite in their filing how under Utah law, an individual charged with or arrested for a criminal offense shall be admitted to bail as a matter of right, except if the individual is charged with a felony, when there is substantial evidence to support the charge, and the court finds by clear and convincing evidence that the individual would constitute a substantial danger, or the individual is likely to flee. Although the court has previously found that there is substantial evidence to support the charges against Ms. Richins, Dr. Crozier's recantation of his previous statement changes the landscape to a degree that cannot be ignored. In order to continue to hold Ms. Richins without bail, the court must first find that there is substantial evidence to support the charge. And that simply no longer exists in this matter. The state's entire theory of criminal liability is that Corey Richins procured fentanyl from her housekeeper, Carmen Lure, which she caused to be unwillingly ingested by her husband in some unknown way, directly causing his death.
There is no physical evidence of this, but only the statements of Carmen Lauber. And these statements are wholly dependent on whether or not Lauber procured fentanyl from Robert Crozier. None of these so-called fentanyl pills were found nor tested. Lauber only believes she sold Corey fentanyl because she believed that is what Crozier gave her. If Robert Crozier did not in fact sell fentanyl to Lauber, there can be no credible argument that substantial evidence of guilt exists.
and they argue that she should be released.
Good argument, Jeremy. I think so. I really do. Remember, when it comes to Utah's bail statute, it's multi-pronged, right? The first thing that the judge has to find, like you just read, is that there's substantial evidence to support the charges. The prosecutor's office, when they've gone through and they've argued their motion to hold without bail up to this point, they've had this distribution bridge. With what Mr. Crozier has come out and said that he never sold fentanyl to Miss Lauber, with that statement, it destroys the distribution bridge, and so it does cut against the substantial evidence nature of the case. And so I think it is ripe for reconsideration, and I do think the defense's argument is a good argument, and I think it's sound.
Let me ask you this. Apparently the Summit County Attorney's Office said it doesn't comment on pending matters, that it's going to respond in the public record in 14 days, as allowed under the court rules. Is that a response you were expecting, and how are they going to respond?
I mean, it's how they have to respond for now. The fact that this has now come to light, it's in the media, they're going to be very, very careful with how they respond. Given the high nature of this, given the allegations that are put forth by the defense team, I mean, like we've already talked about it is a big deal that the prosecutor's office learned about this kind of recantation, this changing of events of saying that he did not sell Miss Lauber fentanyl, but that he sold her oxycodone. It is a big deal, and it opens the door.
And real quick, big picture, I might be a little repetitive, but if the prosecution can't definitively prove how she got the pills, and they can't definitively prove when or how she allegedly put it into this Moscow Mule, you think they still can get a conviction based on the circumstances of his death? Her statements, her behavior, the life insurance policies, her alleged Google searches or searches on her phone. Do you think they could still get a conviction based on everything else they may have?
I think it's a possibility.
Likely the possibility, I don't know. That's going to be something that the prosecution team is going to have to evaluate. Remember, you just listed off a whole bunch of evidence. And even though they don't have the for sure distribution chain like we've already talked about, they still have the fact that Corey reached out to Miss Lauber and asked her to get fentanyl. All we know is that the distribution route didn't come through Miss Lauber. That's the only thing that we know. But the prosecutor's office still has everything that you just mentioned as far as being able to sit in front of the jury. They may say, look, we don't necessarily know how she got the fentanyl, but we do know she was asking for it, and we know that he overdosed on it. Yep, that's a good point. This is an interesting development. We wanted to cover it. We've been focusing on Corey Richins for quite some time. I think this is significant. Jeremy Diaz, thank you so much for taking the time. It was great to see you. Yep, thank you. Good to see you as well. And that is all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. You can follow me on X or Instagram. I'm Oibek. I'll see you next time.